First, humble and profuse apologies. There has been some miscommunication. I got notice for 10:30 for the start of proceedings. And then there was an announcement to say 10 o'clock. But I gave preference or credence to the official notice for 10:30 of proceeding.
Your apologies are accepted. It's not your fault, so you can proceed.
I'm grateful. Now let me just deal with some housekeeping matters. After the lodge of the plaintiff's case, we subsequently received a reply by way of case for the defendant. And in it, they attempted to raise objection to your lordship's jurisdiction. We are prepared to meet that objection if they do raise it formally before the court and to reply to it. So by way of procedure, may I respectfully suggest that we deal with the, in quotation mark, the objection invoking section 53, subsection 3 of the Constitution as a shield against the Lordship's jurisdiction in this matter. We are prepared to deal with that, and then, if needs be, we go into the substantive.
Jurisdictional objections could be entire. If they have raised it in the defendant's case, it only behoves you to address it, because this is you're invoking the original jurisdiction of the court.
Thank you.
And as a result of that, there will not be any opportunity for replies. So in addressing that case, you need to address it, if that's the case. So give you time to do that. That's all we can say.
So we can go into our substantive application?
Yes, you know what they've written, and you can address it, because I am not going to give you an opportunity to reply. You have one bite, you exhaust your bite, but inexhaustive.
As your lordships please.
It's part of their case.
It's part of their case, and it is part of the plaintiff's case as well. We had anticipated they would raise something like that.
In terms of timing, I am going to allow you time to do what is needful. The only thing is that if given, say, 1 hour or you take 1 hour, the other person too might have the opportunity of going as much as that time for equality of arms purposes. But I'm not going to constrict you or constrain you with time, like 30 minutes or 1 hour or whatever. So feel free and go into your case.
My Lord, I'm grateful for any guidance and words of wisdom that may fall from your Lordship's sleep. May I, before I proceed, make an observation and a humble request, given the nature of the case and the issues to be determined. It had been the plaintiffs and their attorneys' desire that your Lordship would sit on bank with the full complement of the Supreme Court, and if need be with the Court of Appeal. What I noticed from the paneling, a judge or two from the Court of Appeal has been brought up, and there are substantive Supreme Court judges who have not been empaneled. We would, in the interest of justice and given the importance of the issues, wish that this court sat on bank, a full bench, to hear the case and determine it, given that it is the apex court.
Well, that is...
I mean, no reflection on the present composition, but just in the interest of justice. So you all, with your wise heads, knock together.
Insofar as paneling of cases are concerned, that is the prerogative of the Chief Justice.
Absolutely.
It is you don't know my judges, I know my judges, and I've chosen. No disrespect for those that have not been chosen. You have to go by it. I am not going against any law. It's the law of the land, and we go by it.
My Lord, I mean, no reflection, none in the least, on any judge who's not been empaneled. But we are only saying on behalf of the plaintiff, given the importance of these.
You're all legal jurists or jurists of the law, and it's left with you. If you want to go by the American system where you...
No, it's not an American system.
It must be the law.
My Lord, if I may, in the recent decision of the United Kingdom Supreme Court on an application which I cite in my authorities, the Chief Justice empaneled in the Supreme Court not less than 11 judges. Because of the importance, this was a challenge to the exercise of the prerogative to prorogue Parliament, and Ms. Miller brought a constitutional challenge, and the judge of the Chief Justice in the UK properly felt.
Dr. Abulai Conte, out of respect to you, both in your age, and in fact, I was a pupil in your class of evidence. I have allowed you, but let us go within the law and let us proceed.
My Lord, I have no doubt it is your prerogative to empanel a court, but that prerogative must be informed by the interests of justice. That's all I say. I move on. May I? May it please the court. This application before your lordships this morning is by way of notice of originating motion, filed on behalf of the two plaintiffs in the matter, seeking the following reliefs. One, a declaration that on a proper and purposive interpretation of Section 38A of the Constitution as amended by Act number 15 of 2001, the controlling provisions stated in subsection 1 of that amendment, namely, and I quote, but no constituencies have been established, are, in our respectful view, conditions precedent to warrant or justify the holding of any general election, particularly for the ordinary members of Parliament, by the district block system referred to as proportional representation. Therefore, any directive by the President to the Electoral Commission to hold any public elections for ordinary members of Parliament
what is in the motion paper, you've given us the first relief prayed for, but the second, I note that you just went therefore, and I have here as number 2. So are you changing that?
I'm just dealing with the application and the relief being sought by the plaintiff.
You have number 2.
Number 2, the declaration by this honorable court that the Fifth Parliament of Sierra Leone, as presently constituted, is itself elected on a constituency basis as provided for in Section 3, Section 38, subsection 1 of the Constitution. These constituencies are still extant and subsisting. That's a relief the plaintiffs are seeking from your lordships. The third relief they seek is that a further declaration that revision of constituencies as provided for in subsection 4 of section 38 does not in and of itself necessarily result in the establishment or dissolution of constituencies stipulated in sections 38 subsections 1 and 2, but rather the section provides for the period when existing constituencies should be revised or reviewed, which review or revision may or may not necessarily result in a delimitation of the respective boundaries of the existing constituencies. When you hold a review, you don't disestablish a constituency. Fourthly, a declaration by this honorable court that will hold the 2023 elections of ordinary members of parliament on the district block system or the proportional representation system for ordinary members of parliament may prevent independent candidates from contesting. May I say, hasten to add, I have no brief for anybody who intends to contest as an independent candidate, but it is a provision of the Constitution that contemplates and provides for them. As provided in Section 77, paragraph M of the Constitution. However, I again just it's my own, if you like, default position. When I say the Constitution, I mean, of course, the National Constitution enacted in 1991. I don't need to go act number this, number that. No. It is the, as my learned friend used, the Kelsenian word, the Guru Norm, which is the highest law as provided in Section 171 of the Constitution itself. The plaintiffs seek also a fifth declaration that to hold the multi-tier elections in June 2023 by the district block proportional representation system will be unlawful and ultra vires the Constitution of Sierra Leone as amended. Sixthly, the plaintiffs seek from your lordships.
Dr. Abdullahi Conte, I hate to stop you, but then you have sent your motion papers, your originating notice of motion, which we have. I want it verbatim as it is recorded. These are the reliefs that you're seeking. And it does not appear you're going by that. It appears that you have your own set of papers which you're reading from. And it does not make for a smooth following of the events this morning.
My Lord,
I have to constantly go through it to decipher where you are heading for or where you're going. These are motion papers that were sent long before, and we need to go strictly by them. If you are calling for an amendment, you have to make the necessary application.
my Lord,
I don't know for my colleagues, they may wish to.
Yes, Dr. Conte. Sorry, Dr. Conte.
yes, my Lord.
There are 9 groups, not so.
9 relief.
9.
Yes.
Yeah. I was expecting that maybe for coherence, you would have just referred to the 9 reliefs and then you proceed. There is no law which says or rule which says you have to start with the first relief. But I was expecting that every council has its own style or approach when it comes to making submissions on the various reliefs. But the reliefs that for us on paper are 9 reliefs. So are you going by the 9 reliefs? Or do you intend to go by some and you don't go by some? Or you are proceeding on all 9 reliefs?
To put the case for the plaintiff. I take what your Lordship and the Chief Justice has said. That was my style when I was at the bar, even when I sat on the bench. I take the papers as having been read. But a recent experience in this very court by one of your learned brothers, he wanted me to move the motion. I said, I thought you had read. He said, no, move the motion. That's my present insistence or attempt to read the motion is born of that experience in this very court. One of your brothers who was the presiding judge is now on the panel. Stopped me and said, no, move the motion. I said, my brother, I thought you had read it. I take it you've read it. Then I can go to
That is one, we read it. But then, if you want to read it, read what is in the motion papers. That all of us concerned do have before us. The one dated 28th November 2022. Even if you're going to read it, it does not appear that that is what you're reading.
I'm grateful, Madam.
Yeah.
My present posture is informed by my experience at the hands of one of your learned brothers. I was used to it when I was at the bar here and when I sat on the bench in other jurisdiction. I take it before I go to court. I've read the papers. Council move and let's go.
It makes good information for everybody here present if you read it. So that's why it's there. If you're going to adopt the attitude of reading it, the practice of reading it, it has to be verbatim of what is stated. Perhaps your colleague is in a better position to help you.
Well, I am relieved and heartened to hear your lordships have read the motion. I'll move on to our substantive case.
Okay?
My Lord, before I move forward, may I, again with your indulgence, state at the outset what this case is not about. This case, we say respectfully, is not about the merits or the demerits of proportional representation system of voting. We note learned counsel for the defendant has prayed in aid, without any evidence, I may say, that it is a system practiced by the majority of member states of the United Nations and most of the stable democracies in Scandinavia. We have evidence of that. We are not attacking the merits or the merits of proportional representation as a system of voting. At the heart of this case, as outlined in the case of the plaintiffs, is the crucial issue of whether or not the 2023 elections for ordinary members of parliament and for councillors of respective wards in local authorities, whether or not, that's the crucial issue, whether the multi-tier elections for 2023 should be held on a proportional representation basis. That is what this case is about. And this issue, this crucial issue, in our respectful submission and view, strikes at the very heart of the rule of law. That is to say, whether we as a country are governed by the rule of law. This is a litmus test in our respectful view in this case. I hasten to add and to make clear that by the laws of this country, particularly its highest law, the Constitution 1991, as amended, proportional representation system of voting is not, and I emphasize, it's not an alternative system of public elections in this country. It is not. When you like, you turn it on, you turn it off. No. Section 38A, which introduced proportional representation system of voting, in the Constitution Amendment Act of 2021, of 2001, I beg your pardon, number 15 of that year, provide pertinently as follows. I'll just read it. It's plain and simple. Where on any law for the time being in force, a date for a general election of members of parliament has been appointed, but constituencies have not been established. Emphasized, but constituencies have not been established in accordance with subsection 3 of section 38. For the purposes of such elections, the President may, after consultation with the Director of the Electoral Commission, direct that such elections shall be conducted on the basis of the existing districts in a manner to be known as the district block system instead of national representation basis. It is therefore reasonable to conclude that the system for electing ordinary members of parliament is on a constituency basis and Section 38 of the Constitution, whose side note reads, not part of the law but for guidance. It's not part of the law, but it is pertinent.
It is therefore reasonable to conclude
that by the constitutional scheme, the election of ordinary members of parliament shall be on a constituency basis, not district block, not proportional representation, on a constituency basis. And the side note to that section reads, constituencies and elections. And the section provides magisterially as follows. Sierra Leone shall be divided into constituencies for the purpose of electing the members of parliament referred to in paragraph B of section 1 of section 74. That is to say, ordinary members of parliament. As the Electoral Commission, acting with the approval of Parliament, signified by resolution of Parliament, may prescribe. It is therefore respectfully submitted that the power granted by Section 38A amending the Constitution to the President to direct elections to be held on a proportional representation basis is not, I emphasize, it's not untrammeled or freestanding. For that matter. That is to say, that power granted the President must be exercised lawfully within the parameters of the Constitution, the highest law. That is to say, exercised within the context stated in the Constitution itself, in the section itself, where no constituencies have been established. We think that is a controlling provision before the President can trigger or direct the Electoral Commission or anybody for that matter to hold public elections in this country by proportional representation system. And the section itself sets the conditions within which and subject to which the power may be exercised, namely where no constituencies have been established. This case is not about the limits of that power or when it can lawfully be exercised. This case is about, I beg your pardon, it's about the limits of that power when it can be lawfully exercised. In this case, I was running ahead of myself in anticipating the objection from my learned friend. This case is not about any advice given to the President or any authority which by section 53, subsection 3 is shielded from review by any court with respect including your Lordship's court. That is a constitutional provision. We are not challenging any advice given by any person, be it the Electoral Commission or any other person. We are saying the directive to order the Electoral Commission to hold the June 2023 elections in this country on proportional representation basis in the circumstances that now exist. I'll come on to this shortly. Would be lawful. So it's not, I'm glad Your Lordship asked me to go on with the case, not to deal with the objection by my learned friend. I came prepared for that as well, but I took it, I had anticipated it. It was, with respect, a misconception of Section 53. Section 53, subsection 3, is what Your Lordship should call an ouster clause. It outs the jurisdiction if its conditions are met. And it is one ouster. Courts generally frown on the ousting of their jurisdiction, and it is strictly interpreted. We say in context, 53 is a red herring and must be ignored. It takes no one any further. We are not challenging. We are not querying. We are not asking Your Lordship to sit in judgment over any advice given by either the Electoral Commission or anybody. So the President, we are saying his directive to the Electoral Commission to hold the elections of June 23 on a proportional representation basis is not open with the Constitution itself, particularly Section 38A as amended. The conditions stated therein are not, as I stand here and speak, present to warrant recourse to that section. The case respect is plainly and simply about the decision of the Electoral Commission, albeit on a directive from the President, to hold the forthcoming 2023 general elections on the basis of proportional representation rather than on constituency basis. That's all we are saying. We are not saying, no, you will not fight. Oh, we are subject on somebody's consultation. No. Therefore, we say the claim or objection on behalf of defendant that this court lacks jurisdiction to entertain the case by the plaintiff by reason of Section 53(3) is, with respect, wholly misconceived and specious and simply a gross mischaracterization of what the plaintiff's case is about. Section 53 cannot, in context, bear the weight my learned friend is seeking to place on it. It will crumble under the weight. It cannot bear it. I don't want to belabor the point, but I bring respectfully to your attention the case of the United Kingdom Supreme Court when it sat en banc on the application of Miller appellant against the Prime Minister respondent. Cherry and others respondent. My Lord, I think.
Can you go over the citation again?
Pardon?
Can you repeat the citation?
Yes, I shall indeed, but we will in due course make copies available. I think copies are available. My learned colleague here has to make copies, if only by way of supplementary list of authority. You have it, my Lord?
It's not part of the list.
Supplementary list. It's there. I can recite the title again, the citation.
Have you supplied the other side?
The copies?
Yeah.
Yes. They have been, yes. I mentioned this
Even now
case.
that you're mentioning it, it's really good for us to have copies of it.
Copies, yes. The registry, I'm told, has copies for your lordship's perusal.
Could I have a copy, please? Is it there? I don't have it. We don't have copies.
Gentlemen, you have copies? You have copies? We have. Thank you.
Yes, Dr. Abala.
But that case is instructive. So,
Where could I find that case in this
Pardon?
supplementary list of authorities? Where could I find that case?
where can you find the case?
Yeah.
It's in the
Yeah. Okay.
May I continue?
Yes.
Thank you. In that case, the United Kingdom Supreme Court had to examine on an appeal the threshold issue of whether or not prime ministerial advice to the monarch, the late Queen Elizabeth II, God bless her memory, on the exercise of the prerogative to prorogue Parliament. They have to examine the threshold issue of whether that advice by the Prime Minister to Her Majesty was justiciable or not. Lady Hale, the President of the Court, sitting with a full court, the complement of 11, I think, which listed, the judges are listed there, gave the unanimous judgment of the court. She stated inter alia, I just go forward, I refer Your Lordship to Act paragraph 33. She started off by mentioning the old chestnut of the Inland Commissioners of Revenue, ex parte National Federation of Self-Employed, the Diplocian dictum in that case. And she continued, it is, in my view, not sufficient answer to say that judicial review of actions of officers of government, department, or departments of central government is unnecessary because they are answerable to Parliament for the way in which they carry on their functions. They are accountable to Parliament for that, for what they do, so far as the efficiency and policy. And of that, Parliament is the only judge. They are responsible to a court of justice for the lawfulness of what they do, and of that, the court is the only judge. I think that is the lesson and the history we learn. Courts have, Parliament fought with the court to say who is supreme. We have in the UK constitutional parliamentary supremacy. We have here constitutional supremacy. And you, as the plaintiffs have rightly invoked your interpreted jurisdiction to determine, it's only to you, everyone is answerable. Nobody can ask your power to do that to you, whether any action taken by the government, the president, with respect, is lawful or not. He cannot himself determine it. He cannot preclude you from determining it. And in the context of this case, Section 53 cannot, I say cannot avail. We are saying that decision is not lawful, it's not within the parameters of Section 38A as amended. And your lordships, this court is the only judge for that, no one else. And nobody can take that jurisdiction from you, which the supreme law of this country has granted you. Not to the president, not to parliament, but to your lordships, sitting in your interpretative capacity pursuant to Section 124 of the Constitution. Your original jurisdiction, original and exclusive jurisdiction. Nobody else can exercise it. No authority, only you. Not even the president himself can say, I make it, I say so. No. This is not a country, if I may use the aphorism of Humpty Dumpty, where Humpty Dumpty said, what mean what I choose them to mean? The question is, who is master? We don't live in that country or such a country. And it is your lordships, it is your task in this case. We urge you vindicate the principle of the rule of law. That is what the plaintiffs are seeking at your hand. What does the law say? Not what anyone says, however high and mighty you may be. Does it accord with the law? That's what we're asking you to interpret. And I adopt with approbation, if I may, and respectfully urge on this court the statement by Lord Hale again, as President in the case I just referred to. And I quote, the court will be performing its proper function under the Constitution, indeed, by ensuring that the government does not use the power of prerogation unlawfully with the effect of preventing Parliament from carrying out this function. The court will be given effect.
The paragraph.
34 million. I didn't mark your copy. I wanted you to read and observe yourself. But I think it's after 34.
Yeah, I could see it.
Yes. And if I may, and we say so respectfully, this court will be performing its proper function by ensuring that the President does not direct the Electoral Commission to hold the forthcoming elections in the country on a proportional representation basis when the underlying conditions for that are not present. We have constituencies in this country as I speak. I'm not sure if Parliament is sitting today, but if you go there and pull out any member of Parliament, it will readily tell you, I represent constituency this or that. There are constituencies. You cannot, in the face of that fact, irrefutable fact, if I may say so, order general elections to be held on a proportional representation basis. You'll be thrashing our constitution, the rule of law, and if I may say so, democracy. The MPs MPs are voted by members of parliament. As I say, this case is not about the merits or the demerits of proportional representation, but one of its glaring, a chink in its armor is the voters don't vote for candidates. They vote for a list submitted by political parties to the Electoral Commission. And they get MPs in the order on which their names appear on the list. Voters want to say, this is my MP. I know him. I voted for him. Not some faceless, somebody I don't know, whose name happened to be on the voters list or on the candidates list with the Electoral Commission. That is not democratic. But as I say again, it is not about the merit and the demerit. I just say it by way of an aside and I move on. We say there are two conditions precedent which must be satisfied to bring Section 38A and its proportional representation system into play. The first is a date for the general elections of members of parliament has been appointed. And two, no constitution. Good. The first condition is when it has been announced for the general election of members of parliament. And the second is no constituencies have been established in accordance with 38(3) of the Constitution. Then, and only then, can the President direct or have recourse to proportional representation basis. We say the determination of these two crucial issues is on the evidence and an analysis of the law. Namely, whether a date has been appointed for the 2023 general elections, and secondly, whether there are present or not present constituencies in this country at this present time. And we say again respectfully and resoundingly, the answer must resoundingly, yes. Date has been announced, and there are, as I speak, if Parliament is sitting, members of Parliament representing constituencies. Excuse me a moment. Thank you. It is a fact. We dare say that the press statement, which is already in evidence before in the affidavit of the first plaintiff, the press statement of 21st October 2022 by the second respondent, the chairman of the Electoral Commission, 24th June 2023, has been set for the general elections. It's a fact. So a date has been announced, a date has been set. The first condition has been satisfied. It is also a fact, as evidence, we just don't say it or make reference, but it is before you that the first plaintiff represents, Honorable Mr. Abdul Kabo represents a current and existing constituency in the present 5th Parliament of Sierra Leone. That's a fact. It's undeniable, irrefutable. So there are constituencies, and he says on oath, I am a sitting member of Parliament. I represent a constituency in the, I think, Kafubulam Lungu Potloko district. Nobody can deny that. Nobody can say that constituency does not exist. However, we say, and I say it with some regret, there is no countervailing evidence, not even a scintilla of evidence from my learned friend on the other side to refute what is the evidence put forward by the plaintiff, that the plaintiff, the first plaintiff is a member of Parliament, the second plaintiff, Mrs. Coker, represents a ward, so there are constituencies, and nobody can deny that. She was elected in the last election, and that ward is still in being. She gives the number of ward which she represents. And I respectfully invite your lordships to take judicial notice, as you are entitled to do. The current 5th Parliament sitting up in Tower Hill is constituted by members of Parliament representing existing constituencies. It's not like we have a blank slate. No one there. These internally displaced citizens or persons, they are all over the place. They are not in their constituencies. No. There is no evidence, none at all, not the slightest, from the defendants to contradict these irrefutable facts that are put in evidence on behalf of the plaintiff. We have to say respectfully that any decision to hold the general elections of 2023 outside the parameters of Section 38 of the Constitution would be unlawful in the face of the evidence and the law. It would not be lawful. There are constituencies. A date has been announced. Ergo, no PR will go by Constitution. In fact, that is the default position of this country since 1962, how soon after independence. And even before, when we had a multiplicity of political parties, the people of this country have been used to trundling out to polling stations to vote for their candidate, not for parties, for their candidate. The candidate may represent parties, but not by list. That has been the history. And it was the same until the unfortunate events in April 1992, when regrettably this country lost its way. Civil war compounded by whatever, and the population was destabilized. Communities were upset, uprooted, scattered all over the country. Some took refuge abroad, and those that stayed had a harrowing time. When, before the military government itself, the military junta, in the interregnum before they stepped down from office, passed a decree which introduced proportional representation system. And this was validated by President Kaba when he brought in the constitutional amendment which gave us Section 38A, which provides for proportional representation. 38A was the product of its time, coming from a war-torn country with destabilized people, no settled communities, let's have the constituencies, let's have the elections and proportional representation. Everybody went along. 1996 was proportional representation. 2001, I believe, 2002. I wasn't here to speak about, but I think this. 2002 was again unproportional, given the recent experience of the country. But since then, my lords, nobody can deny this, we have settled steadily to constituency elections. And the immediate past 3 elections in this country have always been held on a constituency basis, including the 2018 election, which constituted the present parliament. It was on a constituency basis. Are we hankering back to those dreadful days when our co-citizens were displaced and their communities upset and no constituencies? God forbid. And your Lordship do so pronounce. We do have constituency. God forbid. May they continue to be in vain as a mark of our stability as we march on the highway of democracy. We do have constituencies, not proportional representation. We say respectfully again, it should be in the most unusual and exceptional circumstances, envisaged and stated expressly in Section 38A of the Constitution, that could justify the resort to proportional representation system. No constituencies exist. God forbid. We hope the tender shoots of our democracy that have sprung up will thrive and survive. And like bugs, will never die. Winter may come, rainy season may come, but in the springtime in which they sprout again, our democracy will sprout again to march up, to consolidate the stability and peace of this country. Let us go back to the bad old days, which Section 38 implies. No constituencies have been established. May those days never come again. It is, my Lord, I say this with some diffidence, but it's important to note that up to the present, up to the time I'm still standing in this court, there has been no reason or explanation given by the defendants or the government for that matter for the to change the form of election. No reason has been given, none. Maybe you are pretty harm, no. Nobody has told me, I've never listened to SLBC to hear it, to read in the papers. Government or the Electoral Commission says proportional representation will be for the following reasons. Just because of the directive of the President to the Electoral Commission. That is not the law of this country. The law of this country stipulates conditions which must be satisfied. And we say respectfully, those conditions are not present. The first, a date has been set. The second, there are no constituencies. We say that has not been made. There are constituencies. One of how many months for elections? For 5 months. Some political parties are even in disarray. But time is marching on. But nobody has come to explain to the ordinary suffering masses, ordinary public of this country, why we want to change the system of election, other than the, call it whatever, the statement from the Electoral Commission. Why? Proportional representation around this time. No reason has been given. None from my learned friend. None. I dare say the electorate and indeed the general public must be confused and wondering why proportional representation this time around. Why? Nobody has explained it. Why? We have a tried and tested method. Some call it first past the post. Some call it by constituencies. But why go now to a strange creature which we tried in the not so halcyon days after the end of the Civil War? Why take it back? No. And I beg your lordships to say we cannot, without reason. We can only do so if we are within the law, and the proposal to have those elections on a peer basis the proposals do not satisfy the provisions of 38A. There's nothing from the relevant authorities to justify or explain the change of the form of election that would warrant proportional representation. We say, and this is important, the powers that be attempted to make proportional representation as part of the general law for public elections in this country. They did attempt. They were obeying the law. They prepared a bill. Public Elections Act bill. I think we exhibited it in the enclosures to the affidavit of the first defendant. But in that bill, my lord, is published in the Gazette. We exhibited it. Do look at it. In clause 57 of that bill, I can read off what it says. In clause 57 of that bill, it was provided that public elections shall be representation on constituency or proportional representation. But in the debate, when the bill was introduced in Parliament, all hell broke loose. In Parliament, there was a hue and cry by members of Parliament against the proposal in Clause 57 to have proportional representation. As part of the laws of this country. My Lord, the proposal never saw the light of day. Clause 57 was not put to the vote.
Come close to the mic.
I beg your sister. Thank you. Clause 57 never saw the light of day. And the Speaker of Parliament, like the Oracle at Delphi, made a Delphic pronouncement that proportional representation was already part of the laws of this country. It was really the Oracle at Delphi speaking with respect to the Honorable Speaker. The Oracle at Delphi, my Lord, you recall, when you are in trouble or want to go on a mission, you go and consult it. It will give you your fortune, but with a conundrum, and that would be to your peril. He would not explain what it is. He just makes a rapid pronouncement. Speaker, the Honorable Speaker made a statement, oh, it's already part of the laws of this country. And indeed, he was correct. He was referring to Section 38A. But as I had said earlier, 38A has conditions. It's not freestanding. It's not like a tap in a faucet. You turn the head, water comes along. You turn it off. There are conditions. A date has been set. 2 constituencies have not been established. The Honourable Speaker failed to tell Parliament that. And unfortunately, like some unguided wayfarer, those responsible for the election stumbled on their path, on their way, and issued a press release. They say, on the directive of the President, to hold the elections on a proportional representation. And the Speaker respectfully failed to tell Parliament there are conditions. He just made a oracular statement. It is already part of our laws. It is indeed, but it is not freestanding. Conditions are there in 38, which must be fulfilled before proportional representation is brought into effect. And they did not, in this case, satisfy those conditions. That's why we are here, respectfully for your Lordship's court, to guarantee the rule of law, to pronounce on it. We are a country governed by the rule of law, particularly the highest law. 38 years in these conditions, a date has been announced, no constituency. First, conditions are fine, but there are constituencies, and on the evidence before your Lordships, there are constituencies and wards. Nothing for my learned friend. Instead, what the act that came out of the debate finally did, it piggybacked, as it was Section 38A, as part of our electoral laws. But no reference to the conditions in the press statement or the reasoning. Admittedly, Section 38A of our Constitution proportional representation is indeed provided for as a form of election. We don't dispute that. Our case is the conditions stated in the very section, part 8A, are not present, particularly the overriding condition, absence of constituencies. There are constituencies currently in the country which constitute the current 5th Parliament of Sierra Leone. The case for the plaintiff is not 38A, it's not self-standing or self-executing, it's not freestanding or self-executing, just say Shibboleth 38A. You get a pass. No, there are conditions in it. We say, and those conditions are conditions precedent which must be present for the deployment of proportional representation system in this country. And they are not all present, particularly the constituencies. There are constituencies we say unreservedly and with emphasis that this condition, the absence of constituencies, is not present now in this country to warrant proportional representation system. And indeed, from the evidence before this court, it is impossible to conclude any reason to warrant the change to a proportional representation system in the circumstances of this case. I think it's the Americans, they have a thing. If it ain't broke, don't fix it. Our constituency system is not broken. Why do you want to fix it? By a forge. Because there is only a forge. FUDG is a forge. Why do you want to use it? It's not guaranteeing our democracy. It's not enhancing it. And the excuse, I say it's no more than an excuse, by the defendants, that the inability, the excuse that the inability or the impracticability of the second defendant to complete the revision and possible delimitation exercise in the country would warrant holding the next elections on the proportional representation basis. They issued a statement. The revision exercise immediately stopped. Nobody stopped them. But I really beg your pardon. Yes, I'm constrained by. In my days at the bar, I would walk up and down, paying attention to the bench, of course. When I stand still, it affects my cardiovascular system. It was affected. At my age, my Lord, I make...
You want to move?
I beg your pardon?
You want to move or to be moving?
Exactly.
Well, this is the English bar. This is the English bar. It's not the American bar. So.
Well, at the bar, used to move up and down. We had no microphone. Contractions were not there. Our voice is carried. We had no microphone. I do pardon for the interruption, moving away from the mic. We say it is an excuse. has been given to the people of this country. Nothing has been put forth before your Lordship by way of evidence to justify it. Apart from attorney making, I should be careful what I say, my learned friend referencing documents which are not even in evidence. As your Lordships know very well, evidence is that which goes to prove or disprove a fact in issue tendered before a court, either by viva voce or documentary. None from them. Not even an affidavit from the Electoral Commissioner while he abandoned the revision exercise. And now they trump up it as an excuse, calling it inability. Self-imposed inability, self-imposed impracticality. Nobody imposed any impracticality on them or made it impossible. They did not say it. But the learned counsel put forward. And it is not evidence. Sorry. The midterm census evidencing population changes. We say, and I say categorically, that is not evidence before a Lordship. It's learned counsel's so-called reference document. Reference document is not evidence. It must come on attestation, an oath or affirmation by way of affidavit or viva voce from that box and tendered. Learned counsel clipped it to his case for the defendant, and he wants to say that is evidence. Please disabuse his line of it. It is not evidence. It is elementary. Evidence is something that is tendered either viva voce. Yes, sir.
One exhibits attached to an affidavit.
They are.
Yes, and so if you feel strongly that there is no evidence, then
They have to be an affidavit.
sorry, sir. If you feel strongly that there is no evidence according to what you are saying, then you can test the deponent of the affidavit in the witness box. You understand?
It's not evidence.
Sorry.
It's not evidence with the greatest respect. I think there's a copy of Fipsi to look up what evidence is in law.
Carry on, Dr. Conte. Let us be progress. Carry on, sir.
No, is there any affidavit referencing those documents? If they were put by way of an affidavit exhibiting them, then they would be properly before your Lordship's court. But that is not what has been shown. Which? In this case, I respectfully say not a neutral an ounce should be attached to it. It's just a document for what it is worth. I wouldn't even read it if I were in the Lordship's position. Affidavit, attached to them, then properly.
So, Dr. Conte, you're saying that the court should not consider it at all?
Yes.
As evidence.
Absolutely.
That's the position you're taking.
No.
So the issue of weight does not come in.
No, should not be considered. It's just the time and waste of paper. And you call it
Should not even be cleaned. So I should not even clean it. Meaning, I look at it, have some idea of what it contains. And then I know.
You will be wasting your time if you want to read it. Members of the bench, you've been lawyers, you've been attorneys.
I was just going to say to you.
How we need evidence in court. We need evidence by a witness. Who is the witness? Is learned counsel who represents a witness? If yes, I want him in that box to ask him one or two questions.
Honorable Dr. Conte,
Just a minute.
The provenance.
Allow Justice Brahma.
Dr. Conte, we are bound by Rule 92. The defendant doesn't have to file an affidavit. Everything he wants to say should be contained in his statement of case. And I think this is what they've done. The defendant has never the right to file an affidavit unless we allow him. We were allowed this in extraordinary circumstances, for instance in 2018. But strictly speaking, all you have to say, as far as the defendant is concerned, has to be in the statement of case. That's Rule 92.
It's not part of their case.
I wouldn't go to that, but all I'm just saying is that whatever it is they wish to say has to be in the statement of case, according to Rule 92. The plaintiff files an affidavit in support of his motion, and then he files another affidavit verifying the statement of case. But the defendant has no duty to file an affidavit. All he does is say whatever it is he wants to say in the statement of case, and then you can reply if you so desire. You reply in paper as well. You can do so, of course, standing up as counsel at the bar, but you can also file a reply to the defendant's statement of case if, for instance, some issue has been raised there which was not contended by you at all. That's why I just want to point out that there will be an opportunity for whoever filed the statement of case to be cross-examined in the witness box.
What was to stop the second defendant as the commissioner responsible for reviewing, delimiting, making an affidavit and not touching those?
He can do so in the statement of case.
No, that is the only proper way to do it. Not by counsel putting it in his case.
Dr. Conte.
It's not evidence. My Lord, I can give you the authority.
No, the authority is Rule 92.
Yes, evidence is a fact of the issue.
Can we move forward?
Can I go on?
Yes.
Thank you. No. Lord, we are in a court of law governed by rules and procedures. That's why it's called a court of law. I'm on the excuse by the second defendant of their inability and the impracticability to complete the revision exercise.
Dr. Abdullah, we made mention of we taking judicial notice of the fact. You said we should take judicial notice of the fact that MPs in Parliament were elected on single-member constituency basis.
No, well, that's not what I said.
You said we should take judicial notice of the fact that the MPs appointed and elected there by single-member constituency form. That was what you said. So we should take judicial notice of that. I'm just saying, if you say we should take judicial notice of that, even though you've said there was no reference made in the affidavit, of the midterm population census, you say we should ignore it. Is it not appropriate for us to take judicial notice of that too?
Of what?
The midterm census.
You can take judicial notice of anything.
Oh, yes.
My learned friend has not come by the proper route to put evidence which you are entitled to consider. That's all I'm making. The second defendant may be present in court.
We have noted you of that.
Thank you. I was again on the inability or impracticability claimed by the second defendant to complete the revision exercise. We say with respect that does not justify holding the general elections on a proportional representation basis. It is a requirement of law that those constituencies do not exist.
Yes, we noted that. Yes, made that.
And we go further to say, even if the revision exercise had been completed, they may or may not result in the delimitation of constituencies. But the exercise certainly does not result or affect an abolition of existing constituencies. It does not. So those constituencies exist until and unless they are replaced by a recommendation by the second defendant, which is approved by parliamentary resolution establishing new constituencies. That is not the case. We don't have any evidence of it. So he says no more than an excuse. It's even giving me too much. Some credence to call it an excuse. It does not justify it. We are unable, or it's impracticable for us. Does that kill the constituencies which exist in law and the that is the last election? No. It would otherwise suppose the inability and practicability leads to the extinguishment of existing constituencies. I only just have to say it to see how risible that proposition is. It's laughable. We therefore submit that proportional representation system of election to be used in the forthcoming elections in the present circumstances. Cannot avail, given the overriding requirement in Section 38A, where no constituencies exist. The population change is noted. If your lordships want to take judicial notice of it, even though it's not in evidence, do not. The population changes do not, in and of themselves, extinguish existing constituencies. They will make a case for increasing.
Dr. Abuai, has anybody said that the current constituencies are extinguished? Did anybody say the current constituencies are extinguished?
Well, that is the presupposition.
Nobody has said that. Not before.
Pregnant and implicit in the proposal, in the statement by the second defendant.
Until they are reviewed, they exist.
Thank you, my Lord. Thank you, my Lord. Until they are reviewed and delimited out of existence.
And it does not appear to me that that is the case of the other side.
That is what?
The case of the other side.
You put in their case?
No, I'm not putting their case.
I just thought you might have been putting their case.
No, of course, we've read both papers. Even what you're saying, we've read. So,
well, they haven't said that.
Bring it back.
I haven't read it yet. That may be their case.
Let us proceed.
When Landed Council come to answer, you may put it. Not without some help.
Carry on, sir.
Yes. The power to review and delimit constituencies granted by Section 38(4) of the Constitution does not spell the doom or abolition of existing constituencies. That's what you're saying. may review within such a period. You may delimit if circumstances warrant until they have been replaced or extinguished by a resolution of Parliament following a report on the review. That is how it works in law. You, Electoral Commission, will review, will make changes, will make recommendations, which form the basis of resolution in Parliament, which when adopted to establish new constituencies or abolish existing constituencies. And we don't have that. There is no resolution before Parliament. And the population changes noted may warrant new constituencies. That is not with prejudice to existing constituencies. It doesn't make the case to exist. You may say, well, because of the changes, we're going to get more constituency here. Yes, but that is not what we have. Well, that's all I want to say on the 38A and its operation, respectfully. Now I turn to the unconstitutionality of statutory instrument number 83, by which regulations were purportedly made to give effect to the proportional representation system. We say, on behalf of the plaintiffs, the defendants haven't been thwarted in Parliament to have PR, proportional representation basis, as part of the Public Elections Act, now belatedly seek succor through the instrumentality, if I may say so, upon what? Statutory instruments, number 83. And they are both numbered 83, 83, by the way. One for Parliament, one for local elections. It's only painstakingly going through. But the Gazette on his face called them both number 83 and number 83 of 16th November, I think. The Gazette number is there. They are both numbered 83. We say you cannot, through the medium or auspices of statutory instrument, validate proportional representation, which, as I say, the Lordship may note, was given the thumbs down in Parliament. Parliament said, no, we don't want it. Second defendant particularly rely on section 33 of the Constitution for its powers to issue those instruments, which we say are unconstitutional. This is the anchor they want to find their statutory instruments on. And this is what Section 33 says. Subject to the provisions of this Constitution. Subject to the provisions of this Constitution. The Electoral Commission shall be responsible for the conduct and supervision of the registration of voters and of all public elections and referenda, and for that purpose shall have power to make regulations by statutory instrument, has to make regulations by statutory instrument, for the registration of voters, the conduct of presidential, parliamentary, or local government elections and referenda, and other matters connected therewith, including regulations for voting by proxy. And arguably, this section 33 confers power on the second defendant to make regulations. But we say respectfully, those regulations cannot change the format, form, or mode of election. They cannot, not by regulations. For the election of parliament, it changes by regulation. We say on behalf of the plaintiff that to change the format of election for parliament and local authorities is a deliberate matter for the legislation and not for legislation, primary legislation. For primary legislation and not subsidiary legislation. Accordingly, it is submitted to change the format and mode of election by statutory instrument, as these instruments purport to do, would be plain ultra-virus. Forgive the, no disrespect, some bureaucrat, faceless bureaucrat sitting in a elite office makes regulation, changing the form, how they are going to elect MPs and local councillors. No. It is a matter for primary legislation, brought before Parliament by a bill, debated and enacted by law. We mark as a footnote, the defendants attempted to do that properly, but they did not fare well on the floor in Parliament. The proposal was given the thumbs down. Now you have recourse to primary, to secondary, dedicated legislation, which can never happen. To give an officer the power to change how people are going to vote. He cannot do it. And we say further, by Section 33, the power granted to the Electoral Commission, and Section 171 of the Public Elections Act 2002 is to conduct and supervise. Conduct and supervise. And not to determine the format or mode of election. You are given power to conduct and supervise election. You are not given the power to change how you're going to vote. No. That power is reserved for the legislature as a deliberate act of Parliament. We say that to change the format or mode of election is a matter for primary legislation reserved to the legislature, and which in respect cannot properly be the subject of matter for delegated legislation or statutory instrument as in the present case. The word conduct in Section 33 itself say does not include prescribing the mode and form of election or changing the electoral system. The word conduct in section 30 to make regulations for the conduct that it does not include. And therefore to do so by statutory instrument as claimed in this to change the form of election for Parliament and local government as purportedly attempted by the statutory instrument would be plain ultra vires the powers granted in section 33 of the Constitution. Those powers are limited to conducting and supervising, not to change the mode or format of elections. Section 68 of the Public Elections Act, we say respectfully, enumerates what constitutes conduct by Electoral Commission. Section 68. Nowhere in the entire Section 68 is it suggested that the Electoral Commission can, of its own volition or instruction, change the format or mode of the electoral system. The Commission can't do that. It's a matter for primary legislation by Parliament. With respect, not even the President on his own can do it. He cannot. It's there how you do it. We submit, therefore, that the power purportedly exercised through the statutory instrument is in excess of the power conferred by Section 33 of the Constitution and Section 171 of the Public Elections Act, and accordingly are ultra vires. Finally, the Lords, it is respectfully submitted that Section 38 of the Constitution, in particular, imposes conditions precedent to warrant holding any public election on a PR basis. And this is where constituencies have not been established. This condition precedent was not present when the second defendant made his press release announcing that the 2023 elections would be held on PR basis. For the simple reason that there are constituencies in the country and in the current fifth Parliament of Parliament. Finally, I urge your Lordships respectfully to grant the release sought by the plaintiffs in their notice of originating summons. I thank you. Yes, Lord. Yes,
before you take your seat. Sorry, sir.
It's on my phone.
Yes, Dr. Conte.
Yes,
Before you take your seat, you recall I drew your but it's not so initially when you started. When you started making your submissions, I drew your attention to the reliefs. I told you there are 9 reliefs, not so?
Yes, my lord.
Yes, let me just draw your attention to relief number 6.
What's your phone number?
Well, not 6 per se, it should be relief.
My lord, there is a phone buzzer which is distracting me. I don't know whose it is.
Okay.
Could you kindly put it off? Yes, my lord.
Yes, the relief number 6.
Yes.
A declaration that the entirety of Section 38A of the Constitutional Amendment of 2001 does not provide nor contemplate local council elections. The word basis on which local authorities were last elected is a subsisting and lawful basis on which any public elections involving local authorities can be held and not by the proportional representation system. My question is it the same argument? Does the same argument go for in respect of local council elections regarding Section 38A?
The 38A does not contemplate local council.
Yes, but I see it has been made a relief. That's why I'm bringing it to your attention.
That's why we say they had recourse to the statutory instrument, which in our submission is ultra vires, unlawful. You can't change it from whether parliamentary or local by statutory instrument. You can't.
Because you are asking us to make a declaration.
Yes.
So that is why I have brought it to your attention. So maybe you address us on it, even if it is brief.
My declaration is simply to say that the first plaintiff was elected on the basis of a constituency in 2018. The second plaintiff was elected as a councillor in a ward that is still in existence in the Freetown City Council. Also, but they now did a double take and tried to do a bicycle flip backward and brought in the statutory instrument. They realized that it does not cover. So they tried constituency works are not constituencies, works form part of constituency. So they brought in the statutory instrument, which we say still is unlawful. It's ultra vires. Section 33 does not give power to the Electoral Commission to change the mode or format of election. It can only conduct and supervise. And in conducting and supervising elections, it cannot change. It cannot go to and say, hey, yes, you all stand behind the candidate of your choice. And the former line like it's done in other countries. We have secret ballot for a candidate on a ballot paper. Long may that system endure.
Thank you, sir.
Thank you. Thank you, my Lord.
My mic is, I don't know. Thank you, Dr. Abdullah.
Lord, I had written a reply in answer to the objection. I can forward it to the court, give a copy to my learned friend, because I treated it in my submission on the motion. 53, subsection 3 does not avail. It cannot shield.
I think you handled it.
I thought elaborately was going to move the objection, so I had prepared a written response, but I think I took it in my stride in moving the motion. Unless you want to hear any more on it.
their submissions now.
Thank you, my lords. My lords, I would want to crave the indulgence of the bench as to how we address our case. We are seeking leave, my lord, for two counsel to be had. Basically, we have divided the issues and we have certain declarations that we want to address specifically, especially the one dealing with jurisdiction. We intend that will be handled by Mr. Kano, and there is the substantial issue about interpretation and the constitutional instruments which I will be dealing with. Leave is granted. Grateful, my lords. My lords, on the sequence of my presentation, I will further seek your leave to firstly deal with the constitutional instrument, which I'm likely not to spend much time on. Maybe 10 minutes maximum. The constitutional instrument, my lord, or purported constitutional instrument, so to speak. Sorry. The instrument. Can I proceed? Yes. My lord, firstly, we maintain and uphold our submissions file in our case. In our case file, that is on the 8th of December 2022. Specifically, paragraphs 18, 19, and 20 therein. And we will draw the court's attention and possibly style it in our own way to say that is a preemptive strike. A preemptive strike. Even from the submission made, as at the time of filing, that instrument was not law in our country, or the purported instrument was no law in our country. An instrument was laid before Parliament, and there are parliamentary procedures to challenge any instrument laid before Parliament. And those procedures I submit based on the case of SC number 2 of 2005, that's the case of Samuel Hinga Norman, against Dr. Sama S. Banya and others. Judgment of the Honorable Justice Tola Chomsi of blessed memory, dated the 31st of August 2005.
Recording stopped.
Wherein unreported, that this court, my lord, cannot inquire into parliamentary proceedings. I further rely on Section 94, specifically subsection 2 of the Constitution of Sierra Leone. And it was during the interim, further referred to Section 94, 2 of the Constitution. A document was laid, and in the interim, an application filed. And that document is a statutory instrument. And my lords, as I speak, in that application, no certificate of maturity of that document was filed.
Mm-hmm.